Let's talk about parental liability. So I get a lot of parents that call me up and they say, well, my 15-year-old's going to get a new car today, or my 15-year-old went to a party, or I found out we had a party at my house when I was out of town. Am I liable for what my kid does? And my answer varies a little bit, but I start by saying the general rule is that parents are not responsible for the acts of their children. But then there's a number of exceptions to that. Now, the law varies from state to state, so my comments here are really limited to the state of Michigan, but if there are websites out there that will summarize the parental liability statutes in every state. Let's start by examining the Michigan law on parental liability, which says parents are not liable for the acts of their children except up to a maximum of $2,500, and they further put some caveats and limits on that. So let's start at that point. Parents don't have a lot of liability. If you can limit a death claim to $2,500, seems to me like the parents really have some protection there. Interesting side note, when researching this, I looked at the dog bite statute. Now the dog bite statute says parents, or not parents, but owners of dogs have unlimited liability for the acts of their dogs. I just thought that was an interesting dichotomy there, how you're not really responsible for your kid, but you are responsible for your dog. But in any event, let's talk next about some of the exceptions to the law where parents may be held liable for the reimbursement to the injured parties. In Michigan, if you're age 18 or older, you're judged in the civil court system and the criminal court system. But if you're under age 18, you're in the probate court system. It's a whole separate set of laws and rules governing juveniles. And there's a little known provision in the juvenile code that says if a child is convicted of a criminal act in the juvenile court system, that the parents are responsible for reimbursement to the injured party. Here's the example. A 15-year-old broke into a high school, a local high school here, a couple years ago, and he vandalized the building, broke all sorts of different things, and set multiple fires throughout the building. He fled the premises there, and the fires eventually caused the sprinkler system to go off. So the sprinkler system ran for 3 hours in that building before anyone knew what had happened. The fire department showed up, shut the sprinkler system down, but there was such extensive damage, not only from the fire and the vandalism, but water had permeated the entire high school. So the insurance company stepped in and paid the high school's damages. And then the insurance company looked to go after the wrongdoer. They call that subrogation. In this case, they went after the child. The child didn't have any money. They went after the parent. And the parent's attorney said, in Michigan, parental liability is limited to $2,500. Can't sue me. Then that insurance company went to the probate court and said, this child has been convicted of a criminal act, and we are requesting reimbursement under this little-known provision. And the court enforced it. $750,000 of reimbursement was levied against the parents for the child's acts. So there are certain cases where the parents can be responsible. Of course, there's limitations to that provision, but something to think about. The third thing I want to talk about is negligent supervision. If a plaintiff's attorney can argue that the parent had a duty to supervise this child, then the parent could have their own liability. Right? They breached a duty. A good example would be giving your 13-year-old keys to your car and saying, hey, go up to the store and buy a gallon of milk. I'd say that's negligent supervision. And in that sort of scenario, the parent would be liable. Aside from these crazy exceptions I'm talking about, I want to talk about something that's much more real. The law in Michigan is designed to try and protect parents with few exceptions, right? But it is not, I should say, in certain cases in Michigan, parents breach that protection. They unknowingly invite claims by doing certain things. One example that comes to mind is the one I started with, the parent that calls me and says, my son or daughter is going to get a new car today, and they just turned 16. And they don't have any income, so my husband or wife and I are going to buy this car for them, or we're going to lease this car. Of course, the main auto companies are not going to lease a car to a 16-year-old, right? So the parents are always signing on this. There's a law in Michigan that says owners are liable for the acts of anything that goes on in that car. So I always tell the parents, you need to think about whether this is in your best interest. You're going to put your name on the car, and you're going to be liable for everything your child does. A great example of how parents assume liability when they really don't need to. There are ways to avoid that. There are ways to structure the deal so that the parents are protected, and there's ways to insure the vehicle so that the parents are protected. So these are just some examples of ways that parents are liable, and there's lots of risk management techniques that you can use to avoid this liability. If you want to talk more about it, give me a call. My information's on our website under the directory page. Let's talk.